I mean, it's probably just small talk, like, you've sat here for the days, you've heard the evidence, the case is like concluded. Now you have
Violation of the Georgia
there we
Controlled
go.
Substances Act. 61, possession of a firearm during the commission of a felony. And 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is a doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, in any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it.
Taking that drink.
A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols, or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, I need to add that word, probationer. The state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred, or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count 1 a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count 1 is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom. So any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
What were those alternates?
And the rest of you, 449, jurors number 387, 409, 449, and 508.
56 is in.
With me.
56 is in.
And the rest of you can return to the jury room to elect your foreperson.
All rise, jury.
Was the one was it 38? Hold on, let me hear it one more time. Let me write them down. 300 something was the other one.
To elect your foreperson.
All rise, jury.
Oh.
The rest of you, 449, jurors number 387, 409.
I think 387 was the one with the email from the text message from the employer.
449 and 508 to hang back with me. And the rest of you can return to the
409. Yeah, but I think 387 was the one with the employer issue. Where they're like, I heard the case is ending, I heard Doug's out of there. But 56 is in. I wish we could see Love's face. Oh my god. Everybody put a 56 in the chat. Hilarious.
to elect your foreperson.
All rise, jury.
My bad. Let me get caught up. Wanted to make sure I heard those numbers correctly. Look at this look. Look at Doug. Hand on the shoulder. Max's tie.
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now. But you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions, just when we're on break, you're on break too. when the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great. I may see you again, to your fellow jurors. And then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
Alrighty, so we've got our 4 alternates identified. Probably a crazy feeling there. I see some people asking who Juror 56 is.